Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, performance test, writing the Objective Memorandum, structure and IRAC application to PT facts. Let's begin. The Objective Memorandum is one of the most common performance test formats. It asks you to advise a supervising attorney or legal team about the likely legal outcome. The tone is neutral, candid, and analytical. You are not trying to win an argument at all costs. You are trying to predict how the law applies to the facts, including strengths, weaknesses, and uncertainties. A standard objective memo often includes question presented, brief answer, facts, discussion, and conclusion. The task memo may modify this structure, and you should follow any specific instruction. But when no special format is given, this structure is safe and familiar. It helps the grader find your answer and helps you organize your analysis under time pressure. The heart of the objective memo is IRAC: issue, rule, application, conclusion. On the PT, the rule comes from the library and the facts come from the file. Your job is to connect them. The application should be the longest and most valuable part. It should explain why particular facts satisfy or fail particular elements, how library cases compare, and what outcome is likely. Objectivity does not mean weak writing. A strong objective memo reaches conclusions. It may say probably, likely, or a court may find, but it should not hide behind endless uncertainty. If the facts are mixed, say which side has the better argument and why. A supervising attorney needs judgment, not just a list of possibilities. Begin with the question presented. This section frames the issue in 1 or 2 sentences. It should include the legal issue, the key controlling facts, and the question of outcome. Avoid overly abstract questions such as whether there was negligence. A better question is whether Transit Co. is likely liable for negligent hiring when it hired a driver without checking the required safety database, and the driver caused an accident 2 weeks later after a violation that the database would have revealed. That question signals both law and facts. Next, write the brief answer. This is a short prediction, usually 1 paragraph per major issue. State the likely result and the main reasons. Include important weaknesses if they affect the prediction. The brief answer is not the place for full analysis, but it should not be empty. Think of it as the executive summary. Then write the facts section. Select facts relevant to the issues. Present them chronologically or thematically, depending on clarity. Be accurate and fair. Do not argue aggressively in the facts section, but do include facts that will matter later. If a fact is disputed or comes from a particular source, identify that when important. Avoid dumping every fact from the file. The facts section should prepare the reader for the legal discussion. The discussion section does the main work. Use headings that track the legal issues or elements. For each issue, state the rule from the library before applying it. If the library provides a multi-part test, organize around the parts. Use subheadings if helpful. A clear structure might be, the company likely owed a duty because the statute imposes obligations on license carriers. Then subheadings for breach, causation, and damages. Within each section, use IRAC flexibly. Start with a conclusion or issue sentence. State the governing rule. Explain relevant authorities. Apply file facts. Address counterarguments. End with a mini conclusion. The application should be specific. Instead of writing, the facts show diligence. Write, the client discovered the default on March 3rd, contacted counsel the same day, and filed the motion 8 days later, which is closer to the prompt action in Lee than the 4-month delay rejected in Ortiz. Use case analogies and distinctions. If a library case is factually similar, compare it. If it is harmful, distinguish it honestly. Objective analysis often gains credibility by acknowledging unfavorable authority. For example, the landlord will rely on Ramos, where entry was justified by an active leak. Here, however, the maintenance note described a suspected slow drip, and the landlord waited 2 days before entering, weakening the emergency argument. Be precise with conclusions. Each section should end with the likely outcome on that issue. Do not make the reader infer your answer. Use words that match certainty, likely, probably, may, unlikely, strong argument, weak argument. Avoid saying both sides are equal unless they truly are. End with a conclusion if the format calls for it. The conclusion should be brief, practical, and tied to the assignment. It can summarize the likely result and identify next steps if appropriate, such as gathering missing facts or preparing for a motion. Do not introduce new analysis in the conclusion. Suppose the task asks for an objective memo on whether a homeowner can rescind a home repair contract. The library says rescission is available when there is a material misrepresentation, reasonable reliance, and prompt notice after discovery. One case finds reliance reasonable where the contractor falsely claimed to be licensed and the homeowner had no easy way to verify it. Another case rejects reliance where the homeowner received a written disclosure contradicting the oral statement. A third case holds that a 6-week delay after discovery was not prompt when the homeowner continued accepting benefits. The question presented might ask whether the homeowner may rescind when the contractor said he was licensed. The written contract listed no license number. The homeowner checked the licensing database after defective work appeared, and she sent notice 5 days later. The brief answer might say rescission is likely because the license statement was material, reliance appears reasonable absent a contradictory disclosure, and notice was prompt. The discussion would then analyze material misrepresentation, reliance, and prompt notice. Under reliance, the memo would compare the case where no easy verification existed and distinguish the case with written contradiction. It would also address the missing license number as a possible warning sign. Under prompt notice, it would emphasize the 5-day response and distinguish the 6-week delay. That is objective IRAC. Rule, facts, comparison, prediction. One mistake is writing a persuasive brief instead of an objective memo. Do not ignore bad facts or overstate your client's position. Another mistake is making the brief answer too vague. It depends is rarely enough. Give a prediction. Students also write fact sections that are too long. Include facts that matter to the legal analysis, not every background detail. A major mistake is rule dumping. Stating law without applying file facts earns limited credit. Some answers lack clear conclusions. Every major issue should end with a reasoned outcome. For a memo PT, start writing by about minute 45 at the latest. Draft the skeleton before reading is complete if possible. Use headings from the task memo and rule framework. If time is short, compress the question presented and conclusion, but preserve the discussion. The discussion carries the most points. When writing, do not perfect the opening sections while the analysis remains unwritten. A polished question presented cannot compensate for missing application. Draft functional sections first, then improve wording if time remains. An objective memo predicts the likely legal outcome candidly. Use question presented, brief answer, facts, discussion, and conclusion unless instructed otherwise. The discussion should follow IRAC with rules from the library and facts from the file. Address unfavorable facts and authorities fairly. Use case comparisons to strengthen analysis. Reach clear, reasoned conclusions. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.